Many judges are also little tentative or scared of the media, because the media reporters are present in the courtroom. They have a pass. They are accredited to the Supreme Court. And in fact, if something happens at 10:30, at 10:31 you will see breaking news. Because the moment you come out of the court, the reporter will come out of the courtroom and he will, you have cameras in the Supreme Court right there. And he will go to the camera and say, this is what happened in 5 minutes. You will get the news. So some amount of restraint by the media, some amount of restraint by the courts. As I told you, the Supreme Court was meant to be a constitutional court. You will be shocked to know that cases relating to alignment of roads, norms for nursery admissions in Delhi, medical admissions, what should be the speed at which a bus should fly, are matters which have gone to the Supreme Court routinely. So a constitutional court kind of has lost its way and has become a general appellate court over the high courts. The concept was under the constitution that the high court shall be final because it is the highest court in the state. Some matters of constitutional importance will go up. The US Supreme Court decides 80 cases a year. Our Supreme Court decides 80,000 cases a year. And I have told you examples of property, landlord and tenant, commercial disputes, check bouncing, bail, a sentence of 1 year in case of simple hurt, 1.5 years. Everybody will travel up to the Supreme Court. Not to blame the public, because the Supreme Court has opened its doors. They seem to, it's become ad hoc. One judge may interfere in a particular type of case, another judge may not. And I always say, the ad hocism is such that it is built now on the individual. So you have 13 benches sitting in the Supreme Court. So to really test the ad hocism, if the same file is produced before 13 benches on one day, I am sure you will have 6 or 7 different results. Somebody will accept, somebody will not accept, somebody will say go back to the High Court, somebody will say why have you come so late, somebody will say this, somebody will say that. So this is the problem which we are facing in our system. There has to be no ad hocism. There should be well-defined rules that Supreme Court will broadly decide these cases, while the High Court is final on these cases. Today it has become an appellate court. The High Court, the pristine position of the High Court, which was there in 50s, 60s, and the Supreme Court would look at a judgment of the High Court with great respect, is unfortunately gone, and it has just become an appellate court. You've had cases, I have done cases, and so has my friend done cases in the Supreme Court, where a case is broadly argued on first principles as if it is the first court. Nobody cares to read. The High Court may have written 50 pages or 100 pages of a judgment, but the judge will say, yeah, what is the case? So you say this is the case, and he says this is the case. By and large, to show the law, the judge makes up his mind. If the judgment of the High Court is in favor of what the Supreme Court is accepting, it will affirm it. If not, it can write 5 lines and trash a judgment of the High Court and be done with it. So these are some problems which we have in our system which need to be worked out. The court must come back to its constitutional form in which it was envisaged. We cited examples of US, UK. Do you know that in the UK, the Supreme Court of UK does not have any power to annul a law made by Parliament? They don't have that power. Our court has complete power. So with greater power comes greater responsibility. And greater responsibility is the responsibility of restraint, to give respect to the other court, to the High Court. But if you don't, then things seem to be getting out of hand. These are some of the problems that by and large, I would say our system is robust, it is independent. But the most important thing which we have to tackle is delay, otherwise the system will collapse. I also wanted to In fact, the center asked me to name 2 or 3 judgments which have had a great impact, one way or the other, either in favor of the citizen or against the citizen. So I would say the first major judgment of the Supreme Court which had a great impact, or which still has a great impact, everlasting impact on the Constitution and on Parliament, is a judgment called Keshav Bharti. It is a case where the strength of the Supreme Court in 1973 was 13 judges. All the 13 judges sat together in one court. And for doing other routine work, some retired judges were appointed ad hoc for 1 year, because all the 13 judges sat together. So that was a case relating to the power of amendment of the Constitution by Parliament. Parliament has complete power to amend the Constitution, provided this procedure is followed, which I have explained. So a question arose, an extreme question. Suppose a current Parliament was to amend the Constitution and say that this Parliament will be the Parliament forever, meaning thereby that there will be no elections. And they have, suppose you have 500 people out of 572 of one party, and they were to amend the Constitution and say that this will now become a permanent Parliament and you never need to have an election because the law says you can amend and be amended as per the procedure. So what happens? So in that case, for the first time, the Supreme Court said, in that case for the argument by Mr. Palkhiwala, the legendary lawyer, the Supreme Court said that yes, you have absolute power to amend, but there is one restriction on that power, which is to be read into it or which is built in, which is not written there. And that is that you can't amend the basic structure of the Constitution. Basic structure means the basic foundations. Let's say foundations of a house. If you cut the foundations of a house, the house will fall. If you cut one pillar, it may not fall. But if there are 8 pillars and you cut all 8 of them, it's going to fall. So they said you can't touch the basic structure. What is the basic structure of the Constitution? That there will be a Parliament. That there will be elections every 5 years. That there will be an election commission. That there will be a Supreme Court. That there will be a High Court. That they will be appointed independently. That they will have independence. That you will have separation of powers between the judiciary, the executive and the Parliament. All these are basic structures. So this is one very, very important thing. But an equally disappointing judgment, which came soon after this judgment, was during the emergency. That is a judgment called Additional District Magistrate Jabalpur. During the emergency, it was argued that fundamental rights available to citizens are suspended. That means if you are in jail without a warrant, you have no right to move a court. Because otherwise you have a right to move a court and say, why should I be in jail? In that judgment, the High Courts stood up. And the High Court said that even during the emergency, fundamental rights of life and liberty of a person, that they cannot be detained except in accordance with law, those rights will remain. Appeal was carried to the Supreme Court. And sadly, that was the darkest chapter of the Supreme Court. The Supreme Court reversed the views of 9 High Courts and accepted the statement of the then Attorney General that if a person is abducted by a policeman and killed in a police station, even then he will have no recourse. This was accepted by the Supreme Court. It was obviously the darkest chapter. The prominent judges who were in that judgment, in fact, publicly apologized after the emergency was lifted. And the Supreme Court failed to uphold the views of the High Court. So these 2 judgments came within a very short span of time. Another judgment in which I feel the Supreme Court has let down people is the judgment on the rights of gays and lesbians. There is a provision in the penal code which says that it is a crime to have sex against the order of nature. This was framed in 1860 and this was reflective of Victorian morals of England of those times. We have had no such sanction in our civilization over thousands of years. This law was challenged. The Delhi High Court overturned this law and said that it cannot be a crime because it has accepted that there are people who are born in that manner. So it cannot be said it is against the order of nature. But the Supreme Court reversed that. Reverse that view means that the offence is back on the statute. We copied it from England. England has abolished it. So there is no crime. In the US, in 1969, the US court upheld this law as a crime. But in 1985 or 2000, I think 2003, the Supreme Court of the US reversed its view and said it cannot be a crime. So this is one recent judgment which I think has not moved with the times. After a Supreme Court judgment is delivered, there is very little recourse in the court. The recourse is with Parliament. The Parliament can remove that section and provide that there won't be any punishment. But Parliament, as you know today or nowadays, is pretty stuck. Nothing gets passed in Parliament, so that's on the back burner. The only limited way is what is called a curative petition, in which there is a very small window. And before I became the Attorney General, the curative petition is required to be signed by 2 or 3 senior advocates practicing in the Supreme Court. So I was the first to sign that petition that the Supreme Court should recall its judgment. That petition is still pending. It's not been heard for the last 4 or 5 years.